Filipinos are known for being creative and innovative, oftentimes inventing new ways and items to improve their quality of life, which is why the government created and enacted RA 8293, or the Intellectual Property Code of the Philippines.
A work is protected from the moment of its creation. Sa batas nating umiiral, Republic Act 8293, na doon nakalista ang lahat ng mga pwedeng ipa-copyright. Pero sa batas natin, may registration na tinatawag. Yung registration na yon, magagamit mong patunay kung kailangan mo nang maghabla ng mga taong illegal na kumokopya ng gawa mo.
The government has recognized the importance of acknowledging the rights of persons such as scientists, inventors, and artists to intellectual rights, as it is vital to the development of domestic and creative activity, attracts foreign investors, and ensures market access for our products.
Legally, ang sinasabi dito, kapag ikaw ay may copyright, may karapatan kang huwag pakopyahin yung iba. Right to distribution, right to first reproduction. Siya lang yung merong karapatan para i-reproduce yung kanyang nobela o kanyang libro. May mga pagkakataon o may mga sitwasyon ayon sa batas na hindi mo na kailangan humingi ng pahintulot sa copyright owner. Kapag kailangan mong ipa-reproduce yung copyrighted material na yon para sa pansarili mong pag-aaral, hindi mo naman siya binibenta. Yun yung mga halimbawa na hindi mo na kailangang humingi ng pahintulot sa copyright owner.
However, many still have limited knowledge on the Intellectual Property Code, and there are even some who are in the business of infringing the rights of these inventors and artists. With this in mind, what does the Intellectual Property Code state about protecting the rights of those who have applied for it? What acts are considered as violations of the Intellectual Property Code? What agencies are in charge of implementing the Intellectual Property Code? Good evening. You are watching Legal Help Desk on the Solar News Channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Rod Nepomuceno. Tonight, we will discuss your legal rights on the Intellectual Property Code, what you need to know about copyrights, patents, and trademarks, and what you need to do to protect your ideas and items that fall under intellectual property.
Our guests for tonight are Attorney Rod Vera of the Vera and Associates Law Office and Attorney Bayane Loste of the Fortune Narvasa Salazar Law. Good evening and thank you for being with us tonight.
Good evening, Karen. Good evening.
Thank
you. Yeah, thank you for having us. Thank you.
And Attorney Bayo, good evening. Yeah. So this is one of the more interesting topics. At least for me, this was the topic in my thesis when I was in law school before, when it comes to trademark infringement. And lalo na now, it's very relevant because we heard about the story of that student who was plagiarizing his works or parang copyrighted works, and we also heard about this digital media portal using photographs of other
student who won an award for a photo contest wherein he used someone else's photo.
Yes.
And also, we always see raids of
mga fake goods, di ba? Mga
fake DVDs, and yet people still keep buying.
Yes.
So I guess that's one aspect that we have to clarify here. How serious are the penalties and what acts are considered as violations?
Yes.
So first, let's begin by first understanding
defining
this law.
Maybe defining the three, copyrights, patents, and trademarks. Attorney Rod, you wanna
Okay.
take a shot at it?
Intellectual property, it's a branch of law that protects ideas. And as part of or as a result of human creation, we have three what they call branches of IP law. There's copyrights, patents, and trademarks. It can easily be differentiated by the concept of the idea. If the idea is artistic or literary in nature, then it falls under copyright. If the idea tends to have a utility, where there's a use for it, then it will come under the purview of patents. If the idea is regarding a logo or a business name or a brand, then it falls under trademarks. And each of the three branches have their own limitations and what can be or cannot be either a copyright, trademark, or a patent.
Maybe Attorney Vera, for it to be clearer to our viewers out there, maybe you can give examples. So for instance, if you're a business person and you start making shirts that has the similar logo of a brand, for instance, you have an alligator there. So there's a famous brand that uses alligators. What kind of infringement is that?
Well, that would be trademark infringement, because if that animal would be confusingly similar to the famous brand, then the owner of that famous brand can file a case of trademark infringement against that person who is printing those similar shirts.
Okay, so fake bags, fake shoes, yan yung mga tinatawag nilang copies, that's trademark infringement.
Because it tends to cannibalize the sales.
Yes,
diba?
it dilutes the brand, the original brand, so the major brand would then lose its value.
Yeah.
People would think that buying the fake product, it's inferior, and then that inferiority will be then tagged to the original brand.
What about copyright infringement? Can you give an example?
Maybe you want to cut when it comes to copyright.
I want to add on the trademark infringement. There's a new case. It's a Levi's case. It was released last year. Live's jeans, and then the Supreme Court said that there's no infringement. Apparently, they're trying to say that for those small companies who make sure that they let the people know that they're not the actual source of the original brand, then they can be let off the hook. Yun yung nila. So for Levi's, this particular shop in I think it's in Manila, they produce this jeans with Levi's, the
logo.
The logo, not only the logo, it's the knit. They're trying to reproduce the knit, and then apparently, aside from the knit, they put there the source of the jeans. So they said that, no, you're excused because you're actually saying that it is not coming from Levi's. You're coming from this particular local company.
But this was here
in the Philippines. Yeah,
but the logo looked exactly the same.
Yes, but they said it's only for it's a Philippine company, and then they said that they're not in any way connected with Levi's. Levi's straws.
There was no I guess intent, or maybe there was no blatant.
Yeah, the Supreme Court saying if you can show that you're not trying to source yourself, or not trying to confuse other people from the foreign brands, then
that's an interesting decision. This is a Supreme Court decision.
Supreme Court decision last year.
What about if you have fake bags? There are several
marami yan.
bazaars,
Marami yan.
and some of them, pag binasa mo closely, like Louis Vuitton, pero yung Vuitton, imbes na V-U-I-T-T-O-N, Vuitton.
Yeah.
So wrong spelling.
Yeah.
Can they say, but this is not trademark infringement because
Yeah,
iba naman
hindi
yung
naman-
spelling.
hindi naman
Pero
eksakto.
andun yung LV, yung color.
Yeah.
but they must show exactly in the same product where it's coming from.
Yeah.
I think that's a lesson from the Levi's case.
Because if there's an intent to pass it off,
Yes,
diba?
yes.
Then that's where the deception lies, and then that's where the penalties will fall. No?
The Supreme Court called it post-sale confusion, meaning they knew they were buying jeans that were not Levi's, hence no confusion.
All right.
So that's what they.
Let's go naman copyright and patent.
Yeah.
Okay, so that's trademark, diba? That seems to be more common kasi a lot of people, they go to Tiangues and buy all of these. There's imitation A, may imitation B, may mga quality pang ganun, diba? But let's say copyrights and trademarks naman. This is
Or patents.
copyrights and patents, right? Yeah. Tony
So
Bay?
copyright, for instance, kanina it was mentioned that in our previous yung start natin dito when they looked at books, and our interviewee was saying that if it's for your personal use, you can copy portions. But what if, this is famous in law schools, I see this in my classmates. Sometimes they get a copy of a book, borrow it from the library, and then photocopy the whole book, have it binded, because it's cheap in our university in UP. Is that copyright infringement?
Kung massive, if it's massive, yes, it is. It is.
But
yes.
if you
It's
borrow
fair
the book
use.
from the library, photocopy the whole book,
Just for you,
and use
just
it
for yourself.
the whole semester, can you say, it's for my personal use, I'm not infringing? Is that copyright infringement?
I would say yes. Kung talaga it's really massive, and it's and you're actually removing the proprietary right of the author from the book.
Yeah, because in a way, he should have earned from
That
you.
copy, yes.
By
Right? With the
the
one who's
actual-
copying, he should have earned
Yeah.
from you. He should have bought the book,
this,
right?
there has been efforts to really decreases the price or the value for publishers. You know, the foreign books,
Right.
they want it in
Tax-free.
paperback, and then you use cheaper paper,
Right.
or even make it less, not the hardcover but paperback also.
Yeah.
So efforts that they're trying to do to make sure that even for the students, for us students, even from law school even, would manage to, they can afford the price of these books.
I see, right. Now, when it comes to patent naman, we're just clarifying the three, copyright, patents, and trademarks. So patent naman, it's, as you mentioned, it's a unique idea on a particular utility. For example,
Yes.
you invent a car rack, for example, with a unique design. Diba? That's where it falls. Now when it comes to software, for example, would it fall under copyright, or would it fall under
Software
patent?
is copyright.
The
It's
law.
copyright.
But if there's a connection between the software and the hardware, it's so integrated,
Then
it can be patented. It can be patented. You must show the connection between the software and the hardware.
Okay, like mobile apps, for example.
Mobile apps that cannot function without the hardware.
Right.
So,
So there is.
unless yung mobile apps, you can do what? You can have different kinds of software or operating system. Then
Yeah.
it's actually software, not.
Yeah, so it's
So
more-
that's
it's more
copyright
than-
copyright
infringement.
infringement.
Here's
Yeah.
another question. What if you copy the formula for food, for a recipe of someone else? For instance, you already have someone selling a pastry that's their own recipe, and then you copy that recipe and then start selling it as well. Is that a patent infringement, or?
No, that's the recipe. It's not. It's not.
protected.
Yeah, it's not copyrightable
It's not
unless it's
copyrightable.
part of a book or a presentation or say part of I don't know a television show. Then it's the recipe would be part of a copyrightable product. But if it's just how do you cook adobo? These are the steps of cooking adobo. These are the steps of cooking, say, vegan langgunisa. These are the steps of, say, cooking tinapang usa.
But how come you see sometimes like secret recipes, or even people saying Max's fried chicken recipe is a secret, or KFC?
Or
So,
Coke,
trade
for that.
secret.
Yes,
Remember,
diba?
Coke,
secret,
Coke
yeah.
has its formula, right?
That secret is what? Is that
Trade secret.
protected by? Okay,
That's
so
trade
it's not.
secret.
That's a trade secret.
Yeah,
doesn't
the
fall-
owner of the intellectual property would decide, I won't have this registered as either as a formula or as a.
Because it's a trade secret.
It's a trade
So you're
secret.
gonna
That's
keep it.
why, yeah. So it's
So
their decision.
they can't file for infringement because hindi naka-register
you
yung
have-
formula nila.
So you have everyone else
Yeah.
trying to copy the flavor, they're
Right.
trying, especially the
Yeah.
crispness of the skin when they cook
Yeah.
it, or
Yeah.
say the taste of the beer when they're trying to.
Right. Now, Attorney Raj, how do you, you have copyright, trademarks, and patents. How does one register for this? I mean, that seems to be, for a lot of people who are coming up with these ideas. Alam mo naman Pinoy, di ba? They
Yes,
come up
yes.
with really brilliant ideas. So,
Let's go by degree of difficulty. Patents. When one registers or tries to apply for a patent, he has to go to an application, and in that sense, one has to put the invention into words and diagrams, and that goes under a examination by the Intellectual Property Office.
okay. So
And
the Intellectual Property
Yes.
Office under
The,
the Department of Trade.
Yes, the DTI. And it follows, it sees whether the patent or the invention would fall under the, what they call patentability, whether it's new, it's applicable in this industry, and it's well written so that a person skilled in the same art can reproduce it from that diagram.
And make it work.
And make it work,
Yeah,
yes.
okay. All right.
And that
So that's
has,
patent.
Yeah, that has a 20-year protection.
All right.
For trademarks, it is one undergoes another application with the IPO, and it looks whether it's unique in the sense that it's not confusingly similar to another trademark or to another internationally famous trademark.
Or sound similar, or
Yes.
you know, yeah.
Now, to copyright, the law says registration, but our Supreme Court has defined it as a deposit. Because copyright, as mentioned earlier, starts from the moment of creation. So the protection for copyright doesn't start when you apply
Right.
in any government office. It starts from the moment of creation.
Okay.
And the law also says that it is irrespective of the way it was formed, its
Right.
mode of expression, and also its content. The only thing you have to prove is originality and the time of creation. The law provides that you can deposit the art or literary work with the IPE office, and you get a certificate. And that's one of the proofs of ownership, but it's not ironclad. The Supreme Court has determined that it's only prima facie, which can be rebutted.
Can be rebutted.
Okay.
All right.
Now
Okay.
we'll start answering
Yeah.
questions
Yes.
from our viewers. We'll
Okay.
start with Eduardo. He's asking, I opened a company last 2011 and created its logo to identify itself from my competitors, but it was not trademarked. I found out that a multinational company started operations in the Philippines and has a similar logo. What would be the best way to protect myself and my company, especially since the logo which we conceptualized?
Or Eduardo conceptualized
Yes.
it. Yeah. Okay. All right. Okay. So,
it looks like
Attorney Bai,
he
what are your
made
thoughts
this
on
logo
that?
and there's suddenly someone using it.
If depends if the multinational company is able to show that it's been in use, say, in internationally, or it's a well-known mark, then it's a matter of, say, the company saying that, oh, we've been trying to make sure that this is commercially available throughout the world, and now you're trying to copy just because we're not here in the Philippines, pwedeng sabihin.
Yeah.
But for Eduardo, a good thing would be to, even before you start the company, you have 3 years to use it. Even before you start your company, why don't you register your mark immediately? And then even before your company has been established, then you can assign it later on to your company once you've established it. Anyway, you have 3 years to use that.
All right. Okay.
Okay.
Now, Sab is asking, there's a digital art competition that requires me to notarize my artwork for copyright purposes. What are the steps for applying for a copyright, and how much would it cost me? What should I apply for one, or where should I apply for one?
There are two offices that handle copyright registrations. There's a National Library,
Okay.
and there is as of 2 years ago, the IPO, or the
Alright.
Intellectual
So you
Property
can-
Office, accepts copyright registrations.
Okay.
And I think there's a nominal fee. It's, I think, under 500, I think 250 pesos. And the question is, why do I have to notarize? Because the copyright application has to be notarized. In
Under
a sense,
oath.
yes,
Yeah, it has
what
to be
you
under
are swearing to is that the work that you're trying to register as a copyright is yours.
Should be yours, yeah.
It's your original
Okay.
creation.
All
So in
right.
case there's an action or a suit based on that, that subjects the person.
Is that a tedious process, just for our televiewers?
Actually, it's not.
benefit,
It's not. The National Library does accept, and it's not as tedious because there's no criteria for approval. You just have, it's basically just you have all the requirements, formal requirements, and once that's completed, they give you the certificate.
It's under oath, so
Yeah.
you can be, you can
yeah,
go
there's
after
perjury.
perjury.
Yeah.
So when you say that this is mine, then
There's no examination as to whether it's art or literary enough. There's none. As compared to trademarks and patents, for patents, we have to test whether it is what they call part of prior art. Is it an old invention? Is the improvement?
Or is it part of an ordinary way of doing things?
Exactly,
a common way
yes.
of
So
doing
that's the examination
Yeah.
process, which I said there's a difficulty or degree of difficulty from patents, trademarks to copyrights.
Okay.
Okay.
And I guess later on, I still have a lot of questions
I have a
about how
ton.
serious are the penalties, considering there's so many people, again, buying from Changgis, using
Yes.
fake products.
And-
So we'll ask more questions later. We'll take a short break and we will return. We discuss more on the Intellectual Property Code, so stay tuned. Did you know that even though you have applied for the intellectual property rights of a certain invention or creation, such as music, movies, movies, or literary works, that all of these have validity periods. In the case of copyrightable works, their validity period are as follows. Literary works are valid during the lifetime of the author and for 50 years after his death. Applied arts are valid for 25 years from the date of making the work. Photographic works last for 50 years from the publication of the work, and for unpublished work, 50 years from the date of the making of the work. For audiovisual work, 50 years from the date of publication, and if unpublished, from the date of making the work. Sound recording also lasts for 50 years from the end of the year in which a recording took place, and for broadcast recording, 20 years from the date the broadcast took place. For trademarked items, registration is valid for 10 years and may be renewed for periods of 10 years each, while invention patents are valid for 20 years from the filing of the date of the application. Welcome back to Legal Help Desk, and we still have with us Attorney Rod Vera of the Vera and Associates Law Office and Attorney Bayani Loste of the Fortun Nervasa Salazar Law Office.
Yeah, and we got a ton of questions. I think
Yes.
I think one
We were
of the
talking
things
about first,
Yeah.
I'd like to pick up from the protection kasi we were mentioning the periods, for instance, that if you publish a photograph, it's 50 years from the time you publish it, meaning after 50 years, your photograph may be used by other people without infringing on the right of the person who took the photograph. Now I'm curious if you know about Happy Birthday, because it's apparently a very controversial song.
Someone
because
claims to have
someone
written it.
claims that he composed it, and apparently every time you sing Happy Birthday, you're supposed to pay royalties to this original, like the composer of this song. And I don't know if this is true, but
It's true.
I heard that even for movies, that's why they avoid singing it the
Yes.
way we sing it in birthdays. It's because they have to pay royalties. So maybe this is something that you can expound on.
It is, right as of today, that's the tune Happy Birthday is owned by Time Warner. And for movies and TV, that is why they avoid singing that, because they would avoid paying royalties. As far as I know, if it's in a movie, it's upwards of $10,000 as a royalty fee.
Just to sing
Yeah, it
Happy
is.
Yes, just sing
Birthday.
Happy
It
Birthday.
is.
That's why
That
in
expensive.
movies and TV, if you notice, they sing for He's a Jolly Good Fellow instead of Happy Birthday. But for singing in a birthday party and a private affair, that will not be
That's fair
subject.
use.
It's not fair use, and it's an exemption in the copyright law. If you perform it within a circle of your family and friends, then that is allowed under the law. If you were to sing it in a commercial sense, that's when
That's
Time
when it-
Warner comes in and gives you
Charges you, okay.
a bill for the.
Thanks
Yeah.
for clarifying, Attorney
Yeah.
Vera. Imagine people would probably start avoiding singing Happy Birthday at home.
But you can sing it in your.
At least he's clarified. At
Yes.
home,
Yeah.
you can sing it,
Yes.
but not for movies,
Yeah.
TVs, like for commercial purposes.
There was a soy sauce brand called Happy Birthday Toyo. What do you have to say to that?
Well, if that's the case, my view would that it's not copyright infringement
Because
because
of
the
the tune.
words, yes. That's why I said it's the tune that is copyrighted, not the words Happy Birthday.
So it's
Good,
the
good.
music, not the lyrics.
It's not
Yeah.
the lyrics. In
What
fact,
about playing movies? So if you, of course, at home you can watch movies and then it's not infringement. But then if you start showing it to a group of people, for instance, in a barangay, as a fundraiser, you show a movie and then you charge for it because it's a fundraiser for a good cause, for instance. Is that infringement?
the law allows if it's for a charitable purpose, then it may be allowed. But if you're charging for it, the charge then would be under you're donating to the charity foundation rather than charging for the viewing. Then
Right.
that is going to be allowed. If
No.
you charge for the viewing, then that would be considered.
No,
infringement.
because
so if you charge
yeah.
just for people to watch movies, then that's already
That's where
infringement.
it
Yes.
Even if you say I'm just showing it from the theater, from my home theater.
Yes.
Yeah.
Okay.
No, in fact, it's interesting you touched on that because for a lot of people who are putting up establishments. Now, I used to work for a retail company, and it was during that time that PhilSCAP got organized. And basically, if you have a store and you're airing, let's say radio, you're tapping on radio and you're airing music, you're supposed to pay particular royalty, right? Can you expound on that? And what are the penalties if you don't?
PhilSCAP does not charge penalties. They collect royalties.
Royalties, yeah, that's right.
So in a sense, if the establishment, the restaurant or store would play overhead music, and that under the law is called a public performance of the work.
Yeah.
And in a strict sense, the owner of the work would want a share or a royalty for that. That's why PhilSCAP, as an organization of I think producers, composers, and artists, they banded together and, as a collective, started going after this establishment and earning what under the law are royalties.
But under pain of penalty.
Under pain of a lawsuit and damages.
Yeah. Right.
But as penalty is concerned, the IP code, as Republic Act 8293, there is criminal penalties for copyright infringement. In fact, there's a first offense, second offense, and third offense. And on the third offense, it ranges from a six-figure sum to jail time.
So so there can be jail time.
Yes,
and now we're on the topic of penalties. Attorney Bai, is downloading movies or TV series or music and putting it in your own iPod, is that infringement?
Yes, it is. That's copyright infringement, yes.
Okay. Because so many people do it, so many Filipinos do that.
Yeah,
I think it's a matter of enforcement. It's a matter of, say, the owners of these copyrights trying to enforce their rights against, say, the IP, the internet service provider, and then the end users. What they're trying to do in other countries is to bring it against the internet service providers, so they would know if there are illegal downloads.
Right.
So that's how they control the spread.
Does it fall under the intellectual property code, or would it fall under another law?
If you were to put it under the intellectual property code, one of the economic rights available to a copyright owner is the right of reproduction. So one can argue that when you download the music or movie, you are making a copy of that. So if you were to argue, the owner would say, by downloading it, you take one copy from the source, whether it be in Russia or in America, and when it's in your computer, that is a copy because there's no physical transfer of the song. So one can argue that is downloading in that sense is infringement. But our laws provide for downloading as a crime under the E-commerce Act.
The E-commerce Act.
Okay.
Under Section 33B, downloading of previously copyrighted material will met you at least 3 years jail time and a fine of I think over 100,000 pesos.
Wow, very heavy. So for our viewers out there, stop downloading. Just buy the movies, buy the music.
I think that's the reason why there are several companies right now. They're making it more cheap for to validly or legally downloaded copyrightable works like songs, movies, series.
At home we have one. We have this brand where you connect to your TV and we're able to buy movies and TV series.
Yeah, but the thing is now it's becoming, for example, if with 3G and Wi-Fi available, if I can play the music without downloading it, I just want to be able to play it right there and then, and then I have a Wi-Fi speaker.
One could call that a public performance.
Okay.
As long as you're within the circle of family and friends, then that should be allowed. But if you're going to plug your smartphone device into a party, then that there's a thin line there.
That's an argument because if it's streaming, say YouTube or other Vimeo or other streaming devices, and is it actually infringement when you actually download the digitized format to your phone or say to your tablet?
It's not even downloading. It's just
streaming.
It's just streaming it. So once that streaming ends, it's not in my phone. Physically, it's not in my phone. So
gray area. It would be a good test case. I think if someone sues.
Yes, that's an argument. That's an argument when just streaming.
The argument here comes from the fact that intellectual property rights are what they call private rights. Meaning it's up to the owner to enforce. The government cannot come in and arrest the downloader or arrest the...
has to be the private owner.
The owner has to come to court or come to the government offices and say, this person is infringing on my work. Let's get him criminally or file a case for damages.
All right, thanks. We have a couple of questions, and this time we have a question from Florence, who asks, does the Intellectual Property Code cover plagiarism? We were talking about that earlier. What would be the appropriate case to file if a person is caught committing plagiarism?
Very controversial.
Yeah.
We had a justice involved in this before.
I know, yeah. And a couple of a senator?
A senator as well.
In his speech,
how serious is plagiarism, and is it going to be punishable under the Intellectual Property Code?
Plagiarism, in my view, is a species of reproduction. And plagiarism, in a sense, is not commercial in nature, but nevertheless, it is a form of reproduction. Now, one has to look at the use of that reproduction, whether it was done for profit or not. But in a strict sense, reproduction, substantial portion of the work, or even a minute part, is, without citing the source, is infringement. Whether it's labeled as plagiarism, it will still under, in a strict sense. Nevertheless, it's up to the author of that book to complain. In fact, when that speech of that senator, the author of that speech actually wrote and said, hey, you are violating my copyright, and but it's up to that person to come here and...
But it is a violation still of intellectual property, right?
Yeah, so it's not the government going after them.
No, it has to be the owner.
We have a caller from Alabang, Avin. Hello, Avin, are you there?
Hello.
Yes, hi, Avin. Good evening.
Good evening,
Yes,
attorney. Thank you for taking my call.
Yes.
Thank you. Thank you for calling. What's your question?
One of the attorneys mentioned earlier about the copyright protection starting from the moment of creation.
Yes.
So how do we define the moment of creation? What are the acceptable evidence or modes of expression for the moment of creation? Is the question clear?
Yeah,
That's a very good question.
Yeah, because if I came up with it and I was in the bathroom singing it, and then biglang, I read once that, Paul McCartney, for example, wrote the song yesterday in a dream, and then when he woke up, just played it, and but that was just his story.
Yes.
Especially since a lot of the registration periods are from the moment of creation. So yes, that's a very good question by Avin.
How do you prove creation? Or use? Is it use?
The moment of creation, you prove it by establishing what they call a timestamp. In today's technology, you can have electronic ways of proving when it was created.
So if you email someone,
very easy for photographs, because sometimes if you it's in the settings of the camera, it will show the date and time. But what about writing, paintings? How can you prove the date of creation or moment of creation?
That's the dilemma of artists and authors today. But the Intellectual Property Code has cured it, in a sense that there's a provision in the IP code that states that when a owner, an author, is suing a defendant, the infringer, if the infringer does not dispute the ownership of the author, then the copyright is then presumed with the plaintiff or the owner. Hence, the defense is not whether you have a copyright or not, it's whether my use is excused or not. So
it's more of a defense.
More defense.
Yes. If I were to sue somebody and say, this is my book, this is my song, if he says that's not your song, so it's up to that person to prove that that song is not mine. He has to prove that his. So that it's procedural, but in today's age, how do you prove the timestamp?
Okay. I hope we answered your question, Avin. Thank you so much for calling us.
All right. Thank you so much, Avin. And now Roberto sent us this question. I'm a professional photographer and have posted most of my work on my website as reference for future clients. A friend of mine informed me that another photographer used some of my photos and claimed them as his. He went as far as to remove the watermark I always cut on my work or put in my work. What should I file against him? Can I also demand that he put down the website since he has been using my photos to gain clients? This reminds me of a case, well, not in a case, but there was this situation where some people were complaining about this digital media portal using
before I
photographs.
interviewed for Solar in News Cafe. Manny Librodo, one of the most famous photographers,
yeah.
Filipino photographers that's known internationally. And he showed us photos that were being used online by other people, even on their websites. They just removed the watermark. So what can this person, Roberto, and people like Manny Librodo file against people who use their photographs?
It's copyright infringement. And then you can ask the website host to take down the photos. Especially now, if it's local, you can ask the website host to do that. There's a presumption that all website hosts, when they are online, they make an undertaking that they're doing this for legal purposes. So if there's an illegal purpose for that, then you can ask the host to take it down.
Now,
So-
if you acknowledge the owner, for example, if you're a digital media portal, you acknowledge that this photograph was, because there seems to be this mentality for a lot of people that if something's already been posted on social media,
It's free for all.
It's free for all.
No, yeah.
All right, so can you clarify on that, Attorney Rod?
The law, when they say that when it's in social media, it's free. The law terms that as the art or the work being into public domain.
Right.
And the public domain is it's an operation of law. Or it only becomes public domain when the protection ceases. As we mentioned before, that for copyright it's lifetime plus 50 years. And so, for example, the songs of John Lennon, since he passed away in 1980, there's a presumption that in 2030, half of the Beatles songs are public domain.
Public domain, yeah.
But public domain is only when you declare it as public domain.
Meaning you're giving up the protection.
Yes.
You're the creator and you say, I'm waiving my right.
Exactly.
Okay.
So, but when you put it in social media, there is no waiver. And as we remember that the waiver must be written, it must be, I think in our laws, it has to be notarized.
Yes.
So by putting it in social media, that is not a waiver of the
Okay,
rights.
that's a good question
no
to
one
answer
can-
because some people have asked me, is it fair for newspapers or other
Digital
media,
media
mass
portals, yeah.
media, to
Yeah.
use my photos, for instance? Sometimes especially for some celebrities, they would post something on Instagram or Twitter with a photo, and then some
It would
either
appear.
newspapers
It would appear
or
in the
on,
newspaper.
they use
Yeah.
that photo and say, but they already posted it on Instagram or Twitter, so that's still protected.
Yes.
Protected, yeah.
Again, it's up to the owner to go after the person who used it.
But
Okay.
protected pa rin.
Yes.
It is protected, but of course, if you don't do anything as the owner,
Yeah.
yeah,
It's the same like
it's
any
fine.
crime. If
Yeah.
someone stole for you and you don't file a case for theft against them, then the
Wala,
courts
wala.
cannot do anything for you,
Right.
But
right?
there is an exception if it's for news reporting. The IP code provides that if the photo is used as a part of a news report, as long as the author is credited as the source,
Yes.
then it's an exemption under the copyright law.
Okay, that's a good clarification.
Okay.
We have another question from Aldous, and he's asking, I created an app for a website. What kind of contracts or legal documents should I prepare and have the developers sign to acquire full ownership of the app, including the codes, the license, and etc.?
That's your purview.
that's
That's your expertise.
Yeah.
Or anybody.
Attorney Bart.
What contracts are you going to require the host?
The developer,
Yeah,
yes.
it's a recognition. You have to ask him to make sure that in your NDA,
Non-disclosure agreement,
all the source codes, the numbers or the letters, when you encode your program, the site that you have developed, you've written, you have to ask the website host to sign a non-disclosure agreement. So that's one. And then a waiver of all the rights against you by the website host. And then, of course, if it's a software, it's copyrightable, then you have to deposit or register, deposit it with the National Library and then the Intellectual Property Office. So those are the three things that you have to really put down in writing when you have your own website.
That's a good thing you mentioned that,
Yeah.
because I think in relation to written work, not website related, that's also a question for a lot of people who work for either newspapers or magazines or even online websites. They ask, if I wrote an article, do I own the article, or is it the publication company or newspaper company that owns it? And I think the IP code has
Usually they have
Provisions
notices.
on this.
Yeah, usually they have notices, especially if you read the fine print legal notice, they'll tell you exactly what are the terms that you have to work on. Are you going to waive your right? Are you going to waive your copyright over that particular piece of written article to, say, the website host or to the news agency? It has to be clear.
It has to be clear, I see. All right. Now we have our last question is from Jose. I design and create websites for a living. I have this one client whom I designed for and refused to release my pay, claiming that I didn't do a very good job. Without going technical about it, they claim that the website doesn't work, but it's more of the problem with the website host. Since they aren't paying me for my services, can I use the intellectual property code against them? The company is based in the States. Can our code be applicable there?
In the strict sense, it cannot be applicable if you're going after your IP rights. The U.S. copyright law and the Philippine copyright, there are distinct differences.
Okay.
But his job is to design websites. Then we have to know more facts because is he working under a commission? And so if that's the case, then there must be written stipulation. What are the rights? Without one, the intellectual property code says that in a commissioned work, the owner of the work is the one who paid for it.
Okay.
But the copyright belongs to the author. The law provides a split in a sense.
All right. Can you clarify that again?
Right.
So the
owner
of the work
is
the one who paid for it.
Yes.
But
But the copyright belongs to the owner.
Okay.
It can be, to give an analogy, it's like when you buy a CD. You own the physical CD. You own the songs.
Because you paid for it.
You paid for it. But the copyright of the song belongs to the artist.
Meaning you can't reproduce the songs
reproduce
just
it.
because
You cannot,
I already own the CD,
you cannot
I
earn
can
from
copy
that. You
it.
can
Yeah.
reproduce it because you're allowed to make at least one copy under the law. But you cannot make money from it because then you're depriving the author.
The copyright owner.
Physically, if you bought the CD for X amount of pesos, you own that CD, you can play the songs as much as you want. But the copyright still belongs to the artist or the composer.
And it has to be clear, right? In the stipulation, like
In
when
the
you enter
commission
into a
work.
contract, who owns what? Like,
Yes.
I'll, for instance, I'll make this painting for you, but it has to be clear that if you reproduce this, will you
Yes.
be owning this or me? Okay.
Yes.
So that's a good tip for our viewers out there. Make sure you read, ask for a contract, and then read it carefully. So. Very interesting
Very
topic.
interesting. Actually, I have a ton more, but
yeah,
I
we
think,
can ask them after the show. We'll take another short break, but before that, we'd like to thank our guests, Attorney Rod Vera and Attorney Bayani Loste, for joining us this evening.
Thank you
so
very much. Thank you, Attorney Raz.
Thank you so much. Thank you.
Thanks so
Thank you
much
for having us.
Yeah. So we hope we can have you again.
Legal Help Desk will return, so stay tuned. Welcome back to Legal Help Desk on the Solar News Channel.
Yeah, that was quite an interesting topic because it affects all of us. There are a lot of people. I mean, you go around in that young
Yes.
and sometimes you don't even know if it's fake.
Yes,
So-
and some of the very important things that we learned today. One, of course, yung differences, copyright,
Yes.
patent, trademark, so people don't get confused. If you're copying, for instance, the logo of a famous brand, marami dyan restaurants that have been
Yeah.
around for a long time, like
the famous
talking
Shangri-La
about
case.
and a fast food chain like
Right.
McDonald's.
Big Mac, diba? Yung
Yes.
mga ganun.
So if you're starting your own business and then it has something to do with burgers, for instance, you can't just copy the logo or kahit kamukha lang of very famous brands already because you might be sued for trademark infringement. And for law students out there, or not just law students, any of the students out there, it's also infringement or illegal to photocopy whole books. Like if you go to the library and then photocopy the whole book and use that for the whole semester, that's not allowed. That is called
It is
copyright
copyright
infringement.
infringement.
So don't do that.
So I guess for a lot of our televiewers, I think the what you really need to remember is that when you're using something or buying something or producing something that's not yours, not original works, you have to be really careful when it comes to that, because especially when you're buying fake goods, that could potentially make you liable. Not just the ones reproducing and the ones who are producing these fake goods, because you're becoming part of the system, and sometimes there are raids that are happening. So I think what's important to really keep in mind is that God gave us all, I guess, the power to create, and so therefore the more original you are, the safer you'll be. So I think that's the rule that we all have to follow.
Or at least pay for talent.
Correct.
What I'm saying is that, like for instance, the music and movie industry, they're both suffering because a lot of people prefer to download instead of, or buy pirated DVDs and CDs instead of buying the original. And you're thinking, kasi mas nakakatipid ako, I'm saving a lot of money by not buying the original. But actually, you're depriving the people who really worked hard for this, the income that they deserve. So that's kind of stealing. That's why this whole law was created. It is, pero yung, kasi yung nasa mind natin lagi, ang stealing lang yung physical eh.
Right,
but actually, when you're depriving income from people who worked hard for it or who thought about it and really, it's their talent that came out with this creation, then that's also stealing. So for people out there, don't download illegally. You can buy from some, I can't mention the brands, but there are several cheap sources where you can buy all of these songs, movies, and also don't buy fake bags, fake shoes, because then it's also pag magka-raid, you might be involved in it, or they can also be confiscated.
Yeah, it's not just a legal aspect to it. There's also a moral aspect to it. Sometimes we want to keep up with the Joneses. We want to have, as you mentioned, a Louis Vuitton or a Chanel bag, and you want it, and you want it to be beside you, and
even if it's not real,
diba? So you have to. There's a moral aspect to it also, not just a legal aspect to it. Now, we shouldn't be doing that. If you can't afford the original one or the real one, then just buy what you can afford, right?
Yeah, exactly. And just to add quickly lang, there are some countries now that in the airport, if they catch you carrying one of those fake bags with the fake, copying famous brands, you can get your bags confiscated.
So you have to be really careful. So, and it can be very embarrassing.
Yes.
Right. So So again, be original. You're creative, and if you can't afford the original one, buy a cheaper version. Diba?
Just basta not the faked.
Not the fake one.
Okay.
Not the fake one. Now, all right. This is the part naman where we read and answer questions sent to us by our viewers via social media. Last Monday, we received a lot of questions regarding real estate laws. Let's start with Angelo, and he says, I'm an OFW who recently bought a townhouse under the Pag-ibig housing loan. After living here for 2 years, 2 months, so many problems started to show up, like with the plumbing, the septic tank, the ceiling, etc. Though the house is still under warranty, I think the house is substandard. Can I get my money back? I think I think with our discussion, with our discussion earlier,
it depends if he can prove that the house is really substandard.
Yeah, so
and
it's evidentiary pa rin.
Also, the warranty, it really depends on their contract, because there are some express warranties, meaning if it's in their contract and the owner, the original seller, was guaranteeing that there's no problem with the plumbing, then he can go after this seller and say that we have to rescind, or meaning you cancel the contract, and you can get your money back. But then if it can be shown that there were no such warranties, and it's really more of the wear and tear and the age of the house that caused all of these problems, then you might not be able to get your money back. But the important thing is, first, review your contract so you know what your rights are. And then second, assess what caused the problems.
Although in this case, 2 months pa lang, so I would imagine.
But we don't know the
warranties,
age of the house before it was sold to.
Tama. Yeah. So that's also a factor. No? So if it was brand new, then I guess yes, you can go after it. No.
Yeah.
Go after and file a case. All right.
We have another question from Den, and he's asking, for delayed occupancy, can that be a ground for cancellation of the contract and to get a refund? This is a pre-sold condo unit with more than a year of delay.
Well, that's
What
a breach
does
of
he mean
contract.
by delayed
I think,
occupancy? Meaning
they delayed. I think that what he means is the developer delayed the occupancy or
you mean
allowing
they were not able
allowing the
to-
buyers to occupy. They weren't
Yeah,
allowed to
okay.
occupy. So yeah, that's a breach of contract. Yeah, so,
One
yeah.
important thing of, yes, exactly, if they promise that the unit will be delivered at a certain date, then it can be considered a substantial breach of the contract, and then he can cancel the contract of sale and then get his money back.
Right. So we have also received some feedback from our viewers, such as Virgie, who posted this on our Facebook page. So happy to view your program on TV. I found it very educational, especially when you discuss legal matters and real properties. Your program is of big help to us with little knowledge of real estate laws.
That's very sweet. Thank you
Yeah,
so
thank
much, Virgie. And another one, Chris commented as well, saying, this is one show which is very sensible and informative. It gives us an opportunity to learn and understand the legal aspects pertaining to pertinent procedures with respect to acquisition, buying, and selling of real properties. It gives a very good understanding on how a buyer does not get trapped into the pitfalls of unscrupulous people. More power into your show, and I hope other networks follow suit in providing informative shows like Legal Help Desk.
Ayan,
It's
okay.
so sweet.
Wow. Thank you very much for all your wonderful comments, and we promise you that we will continue and strive harder to make this show
Yeah.
really work for you.
Yeah, and I'm motivated more now that, you know, when you hear that we're really helping other people get access. Actually, our show today, you know, our advice, the type of advice we were giving, especially when Attorney Bayi was already talking about non-disclosure agreements. Those are very expensive. You have to pay lawyers high
Yes.
fees for that. So, and
Yeah.
we're giving it for free.
We're giving
so
it for free.
I hope our viewers take advantage
so
of
you
that.
continue watching. So unfortunately, that's all the time that we have left for tonight. We'd like to thank our guests who were with us earlier, as well as our viewers who sent us their questions on our topic for tonight. I'm Attorney Nepomuceno.
And I'm Attorney Karen Jimeno. If you have any questions regarding our topic for tonight, you may send them via our Facebook and Twitter pages, and just raise any questions. And also, if you have comments about our show, as well as those who showed appreciation, feel free to send them to us. Join us again next Monday as we talk about your legal rights. Good night.